It's a pleasure to be here today and have the opportunity to give a bit of Frontex views on the European Border and Coast Guard proposal. I wanted to start as a bit of a, if I can say, disclaimer, that I'm going to concentrate on the proposal as the Commission made it, and not on the current text that is being worked to in the negotiation, the political process. As you can imagine, this is quite a sensitive topic at this moment, and it's not my role. I'm representing an operational agency. I'm not a policymaker or representative of any of the EU institutions. But now the colleague from the Dutch presidency, Mr. Sorel, already left, but to say that the Dutch presidency has made an amazing work and effort in bringing forward this proposal. As he said, 4 months to get the Council position is quite already on the Commission proposal, is quite an achievement. For today and my presentation, I wanted actually to, before going and explain what is, from our perspective, the main components or features of the Commission proposal, I wanted to give you first a bit of an intro on the situation at external borders, in particular what happened last year. Because I think you have to put the Commission proposal in context. This is no other way. You have to understand in which context the proposal is, and that's very much also Mr. Sorel referred to. You have to look at the bigger picture and the situation, because you cannot work only in one side with one policy instrument. That's important, and that's a main message that probably will repeat again. When we look at the situation at the external borders, particularly what we have seen last year, the first thing that, strikes us, and I think that we have to have very present also in Frontex, is the high number of irregular border crossings we have seen. Last year, we had 1.8 million irregular border crossings. If you compare it, for instance, to the figure of 2014, which is 285, you see almost a 6-fold increase. That gives you a clear example of what is the pressure that is having for the border guards or the border management community at the external borders last year, and what has to be dealt with. You have also to see, as Europol mentioned several times, that 90% of the irregular border crossings are actually facilitated. There are criminal networks behind sometimes, not some other times, but they are facilitated in any case. How many persons really arrived? Well, you know, as I think Karin was saying at the beginning, there's very important the registration identification. So nobody is really sure about the exact number. We are talking about around 1 million. Because we're talking about 1.8 million, because our irregular border crossings means people trying to enter or enter irregularly, but we are probably also doing double counting. That's why the figure sometimes you see 1.8 versus 1 million of people, all right? But there are other elements that tells us, gives an idea about the pressure at the external borders, like, for example, the cases of refusal of entry or document fraud that you see at the external borders. In this case, the numbers were very similar to 2014, and that shows you that maybe the border management community is a bit at the limit, you know, because the other cases which show infringements or illegal activities at the borders, those indicators remain quite the same for 2015 and 2014. I'm certainly not going to talk about asylum, but you know, as I said, asylum, border management, return, migration management are all very linked. And of course, this was, when I refer to the irregular border crossing numbers, we have a parallel case with asylum applications. We had a huge number of asylum applications, an increase with the last year, and that raises also issues about, in particular, the external borders, on the capacity to manage that inflow and of asylum seekers, to refer them, and also basically that there were, and we saw, processing gaps. So capacities for processing all those people at external borders were not there. So that was one of the main issues. We have seen them, particularly in the Greek islands, but I think also in some of the final destination of asylum countries. So the crisis not only at the external borders, or the challenges. We have also to look very much at the field of return, where actually the mandate of the agency is being extended. And even the return, and also the presidency just put that very clearly. If we look at the detections of irregular third country nationals in the EU, we had a huge increase. We went from 400,000, around 424,000 on 2014 to 700 around 700,000 detections of irregular third country nationals in the territory. But the return decisions, if you compare the number of return decisions between 2014 and 2015, they're around the same. We're talking about 250 versus 280,000 return decisions. What gives us an impression is that the capacities in the member states to handle the flows and also return those that have not right to stay are a bit stretched. That's clear, because we have seen a bigger number of irregular border crossings. We have seen a bigger number of people, third country national residing in residing or staying in the EU. But we have seen that the return decisions and the number of return decisions remain flat. And even there is also a gap between actually return decisions and the effective number of returns. And there we go down to around 160,000, 170,000. If you look those effective returns in 2015 compared to 2014, we'd see the numbers are again very similar. Again, showing how much, despite of some factors that would indicate you that the return performance would have to increase, they remain a bit flat in that sense, or the same. I think that, and of course, there's no question about mixing things, but we have also to talk about the terrorist threat, because the foreign fighters phenomena is something, well, maybe existed before, but has certainly acquired a complete new dimension in the last years. And it presents particularly a huge challenge for the border guard community. And why that? First of all, we are talking about a large number of suspects. According to Europol figures, we're talking about 3,000, 5,000 people, EU citizens. And that's a particular challenging fact because, of course, the controls, as you know, for EU citizens at external borders are not the same as third country nationals. And the border guards somehow also have the important task of trying to prevent the exit or entry of those people. And that gets added. So we have, on one hand, an important migration, asylum, mixed flows at external borders, but we have also internal security threats. And that adds to the complexity of the situation. And last element is the economic crisis. As I said, we cannot take things in isolation. If we look at, in particular, the most affected member state, Greece, we have seen that certainly the economic crisis has weakened the member state, and has left it with less resources, less capacity to deal with a crisis. Because first thing is that when you have a crisis situation, you need spare capacity, you need extra capacity from the different sectors, because they are also, of course, not only public sector and administration, probably also, certainly also NGOs, of course, the EU agencies supporting and the EU institutions. But that spare capacity was difficult to find, because, particularly also because countries like Greece, but also Italy, are very much exposed. It's very simple. You look at the map, and you will see how close the Greek islands are from the Turkish coast. So, and you see that exposure is an important element and explains also why it is so difficult actually also to handle with the flow and control the borders. So in part of just from the landscape and context, and then I go straight to the proposal to summarize, I think it's fair always to ask what sort of crisis we are dealing with. Do we deal with a migration refugee crisis? Yes, certainly. But in certain way, if we look at the big numbers, at the macro numbers, we're talking about maybe 1 million of people who arrived in an area of around 500 million inhabitants, residents or citizens. We also look at, and there is an interesting OECD recent report that explains that the cost or the financial impact for the member states, the EU member states, for the refugee crisis around 0.1, 0.2 of the global GDP. Of course, some member states like Sweden are much higher, but it is relatively low as average. Yeah? I think it's also fair to ask ourselves, what has been the impact of the EU external relations or enlargement policy? Because as it was said, the internal-external dimension is important. If we look at particularly how far our neighborhood policy has been able to really do what it has to do, it means development, stability in the neighborhood area. And I would come in particular to the enlargement countries, where so much effort of the EU has been put to put enlargement countries in the right path, of course, to be part of the EU. But when you have looked at what happened particularly last year with the discussion of the Western Balkan corridor and the destabilization and even the political crisis created, then you have to ask yourself also that, about the effectiveness and how, the EU external action, enlargement policy, foreign policy is working and supporting that. I think we can talk also a bit about the internal security crisis, and in particular the question about how far member states are sharing information when it comes to terrorist suspects. And finally, the political and institutional crisis. I think that certain way there were questions about Schengen, how long will survive Schengen. There were questions about, there was certainly a disagreement among member states and sometimes also uncoordinated measures and national decisions and efforts. So all this added to the complexity, and in this way I would pass to the second part of which is the proposal in itself on the Commission side. And maybe to start is that, well, there was a plan to actually amend the agency, the legal framework, but it was just as a follow-up of our normal evaluation that you would do after 5 years of the functioning of the agency and then 3 years after and so on. But the whole situation that I just explained pushed the legislator, in this case the Commission, to make a much more ambitious proposal than probably they have thought before. First point is that the idea of the European Border and Coast Guard is much more than the agency itself. And that's maybe the most important novelty, but maybe it's conceptual. Then in practical terms, we can maybe discuss afterwards. Meaning European Border and Coast Guard is the sum of the agency and the national member state services responsible for border management. I would draw your attention that there is not only one, but there are several national services responsible for border management activities, depending on we're talking about border checks, border surveillance, etc. I think the core of the proposal is certainly about what we can call the governance of the external borders. There are several elements on this, but I think the most important would be definitely the vulnerability assessment. The vulnerability assessment is a new tool, basically to be carried out, a task that is to be carried out by the agency, and it looks really more in depth into the member states' capacities to face future crises. Our approach is very much future-oriented, through the assessment in full cooperation with the member states, to help them and to create more resilience and better capacities and to cope with the situations. And definitely we want to work with the member states fully and also with the Commission on this. And I think it is one of the elements also that might trigger the next element, which is this urgent action or intervention, which probably you have here. This is one of the most delicate points, because basically it puts the EU in a strong position, maybe decision of the Council, of the Commission. This is something that is still being discussed, based on the assessment of the agency to launch an operation in that country. But it can be, and it's not only about joint operations, and I imagine you're familiar a bit with the agency's mandate to launch joint operations, but it can be also to have a capacity building package together with a joint operation, to look and address those vulnerabilities that we have seen in that assessment. So, in any case, urgent action is one of those important elements, of course, that touches on the sovereignty also of the member states. In any case, it is clear that this will not happen, an operation in a member state without the agreement of that member state. That's, I think, very clear. Then, another important element is the pools. Here, meaning pools is the pools of border guards, pools of equipment that the agency already is having. We are doing this already in several of the amendments of the agency done before and in our activities. The only thing is that, let's say it like this, the Commission the legislator has taken a new step to make them more compulsory, more binding for the member states. Well, let's say it like a compulsory pooling and sharing mechanism, where the agency will have more grip on the national resources. Because actually the agency itself, we have around 300, 400 staff members, so we don't have really the border guards and not meant to send border guards. I mean, it's not our staff, and certainly not me, the one who is going to be at the external borders controlling this. This remains the member state responsibility. But with the pools, we want to support the member states and having more grip, more capacity. And with this rapid pool or standing corps, whatever you want to call it, certainly will increase our capacity and also the possibility to manage better, to have more capacity in selecting the right people with the right profile, and also being even able to somehow evaluate together with the member state to which this person, this border guard that is part of this European border guard teams belong, to evaluate the performance and have an idea about when and guide, let's say like this, the next deployment of these members. And at the end, as part of the governance, and it's maybe unfair to put it at the end because it should be somehow at the top, is this legal definition that the proposal, Commission proposal contains on what is integrated border management. This is a term that has been somehow politically defined in Council conclusions before, I think December 2006, but there is not a proper legal definition. You have, of course, in the Treaty of the Functioning of the European Union, a legal basis for the legislator to adopt measures for the integrated management of the external borders. But there is not a legal definition. So the novelty here is that this new regulation, this new founding regulation of the agency would include a definition and also give a special role of the agency in developing a technical, operational strategy. It is, the strategy itself, quite a strategic issue, because of course this is a basis also for the member states, and that member states would have to follow this technical and operational strategy. So it is sensitive for the member states, because we have seen that there are maybe different even understandings on how this IBM strategy should look like and what are the components and so on. In any case, it is clear that the proposal, as in many other aspects, is really making a step forward, a very positive step, and including a definition on this. Apart from this aspect or chapter on governance of external borders, there is another one very important, which is on the more migration management, because we have to see border management is not an end in itself. Let's forget about that and border control and end. It is supporting migration management, it's supporting internal security. You can even say it's supporting the economic relations and the free trade and the movement of people. So it's not about, border security, or at least not only that. And the Commission proposal in this sense on the migration management part has certainly also important parts. First, these migration management support teams. In fact, what the Commission there has established nothing new, because we are doing it already. In Greece and Italy, we have massively deployed experts, member states experts and border guards to support their host member state, Greece and Italy in this case, in the hotspots, for registration, identification tasks, which are national tasks, according to Eurodac, as you mentioned, Eurodac regulation, or other pieces of EU law. This is national Schengen border code. The identification of the third country national is a national task. But we saw that there was a gap there, and we supported that. So basically, that's institutionalizing or formalizing that task. But there's also, in return, we are doing something like joint return operations. We also had some capacity building activities, but the new step is here actually, and I think my colleagues sometimes tell me this is not really the right word, national return operations. But the idea is that the agency can now not only support several member states who have returnees to go to the same third country back, but just one particular member state also, by providing additional, all type of support. Of course, the return, the charter flight maybe, but also in terms of identification and documentation, because one of the most difficult parts in the return process is the documentation. In that sense, the cooperation of the third country. And I think that certainly we will be, as Alexander Sorel said earlier, we will be talking a lot about return in the next months and years, because it's a very important element, and it's sustaining all the rest, even the asylum policy. So it is a key aspect, and where definitely the agency wants to also play its role according to the new mandate. And then there's a bit of more heterogeneous area. I mean, how would I say, combining in the Commission proposal, extending already a mandate that the agency has today in different areas. The first one, and I would like to mention, is the Coast Guard. There's a new article on the so-called Coast Guard functions. I'm not sure how familiar you are with Coast Guard functions, because it's a term that the Commission proposal has not defined in the proposal itself. But in several Commission policy documents on integrated maritime policy and the Common Information Sharing Environment, they have started to define a bit what the functions are. Well, you have a total of 11 functions. I will not now mention all of them, from maritime safety, fisheries control, search and rescue, very important, but also law enforcement related functions. Of course, border control, which the agency has already, but also other aspects like customs enforcement in sea, or some law enforcement related functions, like, for example, the fight against trafficking of drugs, smuggling of weapons, which is also very important for the internal security. So the new mandate, and what the Commission actually, the proposed new mandate, would allow us to increase our cooperation not only with the EU maritime agencies, but also with some of the national authorities that implement some of those Coast Guard functions. Coming back, you can imagine how difficult it is sometimes dealing with the search and rescue one. This is dealt with international law, is regulated by international law. But certainly many, as you know, probably know, most of our joint operations in Greece and Italy end up in search and rescue operations. So this function is very present in our minds. Still in the area of cooperation, our mandate will be also enforced in the terms of cooperation with other law enforcement bodies like Europol. Our mandate to process personal data will also probably be enlarged. All this, of course, as I said earlier in the discussion, at least under the Commission proposal. Our mandate to cooperate with customs, which we didn't have, strange enough. Customs is the other main authority, national authority present at the external borders. And that was not really regulated in our founding regulations so far, cooperation with customs. So now, finally, we have it, at least in the Commission proposal. And finally, and which is a very also sensitive area, is the cooperation with third country authorities. We have working arrangements which are not international agreements with third countries. There's just a sort of administrative arrangement, cooperation arrangement. But the Commission proposal at least would help us to use some of the tools that we're using currently in the EU context, in the EU member states or Schengen associated countries, export them into the third countries. So we have, for instance, the mandate, as said, to launch joint operation at external borders, at the EU member state external borders. But the Commission proposes actually to do also the possibility, of course, with the agreement of the third country, the non-EU country, to do it somehow on the other side of the border. Because we are working together with the member states on the EU side of the border, on the member state side. But then it would help also to work on the other side. There are also ideas and proposals to also have a closer cooperation with the third countries in the field of return and so on. But anyway, this is one of course, important topic, as you can imagine, also discussed in the ongoing trialogue, and we will see how it looks at the end. Now to come to the final part, analysis of the proposal. I mean, first of all, and I also asked in the title to have a bit of showing, first of all, a bit that this is an evolution. Since I worked in Frontex, this is like 9 years, and even I was working before in the Commission, I have seen many amendments already, well, at least 4 or 5 amendments, taking different pieces of EU secondary legislation to the tasks of the agency. So I see this as an evolution. Doing any analysis, proper analysis now is not also adequate because they're still ongoing in the political legislative process. But I think some key ideas which I would like and can also maybe inspire some questions that could come up. First, we could ask, is there an evolution now from the sovereignty-centered based, sovereignty principle to a more solidarity principle when it comes to border management? And here what I would think is, what I mean with solidarity is more sharing of member states' resources to support that member state exposed. So more compulsory, if I can say, pooling and sharing, but also more integration among the national border management services through the activities of the agency. So solidarity in that sense. Is there also an evolution from, again, sovereignty to shared responsibility in terms of border management? And here, of course, questions you would ask, how do you understand shared responsibility? Well, you have anyway the Article 5 of the Commission proposal, and you can look at it. But is it something meant like, okay, the agency is responsible for this, the member states are responsible for that? You will see that's a bit the approach somehow that the Commission took in the proposal, saying normally member states are responsible for the control of the external borders, but then if, and don't quote me exactly, but they said something like, in extraordinary circumstances and crisis situations, somehow the responsibility will go to the agency or to the EU. Anyway, that would be, I would also raise the question whether, how can we understand shared responsibility as joint responsibility in the control of the external borders? Because certain elements, and I'm sure Jared will develop on that, about accountability and responsibility and who it is important, and also surely picked up in this last phase of the discussions among the legislator about elements on accountability. So in our activities, national activities, and in particular on the aspect also of fundamental rights compliance. But it's important also to just remind you what the agency does not do and what we are not responsible, as I see it a bit like the ceiling in terms of responsibility. I mean, when we say we are not responsible for the control of external borders, so at least I say that remains with the member states. What I'm thinking immediately is that if you're refusing entry to a third country national, if you are accepting that third country national and launching, registering the asylum application and referring it, if you're taking that vulnerable person and put it in custody or with a certain NGO, this can be only, in my opinion, a national member state's decision. I don't see how the agency or the EU can replace. We're talking about the fate of that person, the destiny of the person once it's in the EU. So certain person, or sorry, certain member state, I think, or entity has to take responsibility. I don't see how the EU can take responsibility for that. The same would be on return decisions. Even if we have a stronger mandate on return decision, the decision to expel someone, going through the procedure, coming to that last end, it remains a national decision. It's not, don't see how the EU can really take that decision. That's at least in my opinion. And I think finally, there is clearly an evolution of the agency. That's clear in the new mandate. But that has to be looked also in terms of maybe the role of the management board. Our management board, at least according to the Commission proposal, will have some important, a very much important role that would go a bit beyond that management board that is only a governing board for the agency, but somehow a management board that is taking important decisions that refer to the governance of the external borders. We're talking about its role in the vulnerability assessment, in the IBM strategy, etc., because the management board will decide on that. So that's very much it. Maybe as final conclusion, and the main message is that border management, of course, is not equal to migration management. Migration management is very much a large area, and you know it very well. And therefore, you know, making a proposal for European border and coast guard is an important step, but it's not something in itself that will the panacea and that will solve the problems, all the problems. Is one instrument. Finally, and this is my opinion, personal opinion, it's also that the most important political challenges remain, or the most important challenge actually, and questions are political, and I will mention already. Legal migration, do we need legal migration? Do we want legal migration? Also the asylum, we will find a system for sharing the asylum, fair system to share the burden of the asylum seekers among the EU, and even will we find the proper legal access to the territory, channels, legal channels? Resettlement is one, but certainly I think we have to look a bit beyond. And finally, foreign policies, as mentioned. What is the capacity to impact in our neighborhood and project our security also on migration interest, our EU interest, because migration and home affairs interests are EU policy objectives and EU interests in our foreign policy. And finally, about whether, you know, we want more EU or less EU and all those things. So, anyway, so that's it. Thank you very much for your attention.
Good morning, everyone. Thank you for having me here at ERA. It's always a pleasure to speak at the events, either here or in Trier. And I'm also very thankful for Richard for already doing some of my job. And as you will see, we both had the same thoughts on whether is this such a revolutionary proposal or is this really an evolution. So what I would like to talk you through is a few things. I'd also like to put this proposal a bit in the context, not just of the current refugee, migration, whatever you want to call it, crisis, but also sort of in that broader development, because as Richard already said, he's been there for 9 years. I've pretty much been following the agency for the same amount of time, and also the development of a European border management strategy. And then I would like to zoom in on some of the more innovative elements of the proposal, then say a few words on the negotiations. In my outline, I said discuss the outcome. Well, that was a bit optimistic. Then say a few words about the migration management teams, the hotspots, and also the relation of the future border agency to the European Asylum Agency. A few words on fundamental rights, and then some final remarks. So, first of all, this proposal should be situated in sort of the progressive development of an integrated system for the management of the external borders. And this has actually started off with the Laeken European Council conclusions in 2001 that called for closer cooperation between the border guard authorities of the member states. External border management has always been considered as a conditio sine qua non, as a sort of a prerequisite for free movement in Europe, for the Schengen area. And in that sense, the development of Frontex as of 2005 is exemplary for that. We have seen a consistent call for a reinforcement of the external borders. And I would also therefore take issue with the description of this current migration crisis or a refugee crisis as something new. Migration is here to stay, and it has been around for quite a bit. Of course, the situation has changed over the past few years, but it only really became a European crisis in 2015 as we started experiencing the consequences of that real crisis, most importantly in Syria. And if this is at all a European crisis, then it is mostly a political crisis, I think, for the European Union. And what we've seen in 2015 is that very much, just like Schengen is sort of a prerequisite for free movement in Europe, so was Dublin. And Dublin and Schengen are to that extent two sides of the same coin. So when Schengen is under pressure, that was really because what was not functioning was the Dublin mechanism. But what you do see, and I agree very much, and I'm very glad to hear that from someone from Frontex as well, saying like border management cannot be the sole solution to a crisis. However, what you do see, I think, is a very much, in my opinion, undue focus on borders. Yes, there's a whole range of other initiatives, but first and foremost, we're looking at those borders. And the problem with reinforcing external border control is that, first of all, you cannot practically seal off a territory. You'd have to be North Korea in order to do that successfully, with all the economic costs as well that follow from that. But also legally, border management cannot be a solution to what is essentially a refugee crisis. Also because we have simply international law and European regulations that say simply, well, non-refoulement applies at the border, and also a request for asylum should be made at the border. So all this discussion about the external border management is also to give some sense of security, to give some sense of control in what is essentially a very hard to control situation. And also, in a way, this is not a new crisis, because that whole issue with the control of the Schengen borders already arose in 2011, right after the Arab Spring. We saw it at a much lower level, and that wasn't even a refugee crisis. There we saw a large influx of Tunisians into Italy. Perhaps you still remember that in the wake of the Arab Spring. And Italy was already at that point asking for solidarity. It was Berlusconi at the time, and he didn't get it, so what did he do? He basically provided these people with a temporary residence permit, permesso di soggiorno, which allowed them to move on to France. France closed the border at Ventimiglia, and there we had sort of a mini version of what we've seen at large in 2015. And what was the result of that? The reinforcement, or actually the communitarization of the Schengen evaluation mechanism, and the introduction of Article 26 of the Schengen Borders Code. And that became sort of the rabbit out of the hat in 2015. The Dutch presidency pulled that out at the informal JHA meeting in Amsterdam. Basically that, you can reintroduce checks at the internal borders for public security reasons, but you can only do that for a limited amount of time. And as we were reaching the end of that time that you could do that, they said, well, we have this Article 26, which was introduced in the wake of the Italian-French sort of clash, which said that you could ultimately, for a period of 2 years, reintroduce internal border checks in case there was a serious deficiency in the management of the external borders, putting the functioning of the Schengen area at risk. Hello, that's what we saw in 2015. But there it wasn't the Italians, it was very much the Greek failure to manage the external borders. And that also followed from the Schengen evaluation mechanism results. There was a council, recommendations were issued. But what you very much see is that with this proposal and with the reinforcement of the external borders, the Commission is essentially trying to, what it said in its Commission communication back to Schengen, return to sort of the Schengen system. So not fundamentally depart from what was there, but simply to put it back in place. Although it does mention in a next communication that there is a need to reform at least the Dublin system and look at some of the legal avenues. But I think what is very important is to realize that this is a problem that has been with us for years. It also follows from the incapacity and the, to some extent, even unwillingness of some member states to effectively implement EU legislation, be it the Dublin system or the Schengen system, and that there is now an incredible lot of pressure on these negotiations for the border agency, but that was in the pipeline for a long time. We had the legal basis for an integrated system since the Lisbon Treaty, but already in the Stockholm program, there was talk of a system of European border guards. The idea of a European Corps of Border Guards was actually initially coined already in 2002, even before setting up Frontex. So you should see this proposal for this European Border Agency as indeed the next step in sort of a longer development. Now, what are the innovative elements? Richard already introduced generally the proposal. The European Border and Coast Guard would be sort of an umbrella under which there is, on the one hand, the agency, and the other side, the national border guard authorities, who would share responsibility for the management of the external borders. In a way, Frontex would become, as one professor said, sort of a line manager. It would set out the strategy. It would have a role of supervising through the vulnerability assessment mechanism. And yet what is very important is that there is no actual transfer of executive authority to the agency. It has never had, and it also won't have under this proposal. Frontex will always work through national border guards who've been endowed with executive authority. It is already quite, far going, I think, within a European Union that you can have a border guard from one member state exercising executive power in another member state, but the agency itself, the European Union as such, does not have that prerogative. What are then the innovative elements of this proposal, in my view? Well, first of all, it's that this proposal does not only enhance the two roles that Frontex already had, the operational role, the coordination of joint operational activity, and its regulatory role, supporting the Commission in the application of legislation relating to the borders, such as what used to be the External Border Fund, where Frontex determines impact factors, which ultimately then determine how much money a member state will get. But also this introduction exactly of this supervisory mechanism. And this vulnerability assessment mechanism, this supervisory rule, may also have consequences in the sense that where Frontex used to be, sort of at an equal level and cooperation, it now sort of really is checking member states in how they're doing their job. And that check may actually have consequences. If deficiencies are recognized, are identified, the executive director can come up with a plan how to remedy these deficiencies. But if you're then faced with a member state that's unwilling, in the Commission proposal, the Commission could then take a decision saying, well, this is what you now have to do. And if you don't, the border agency will intervene. Now, it was very interesting when this proposal was presented first by Timmermans and Avramopoulos in the European Parliament. They said, this proposal fully respects the sovereignty of the member states. And then at the same point they said, but member states will have to accept that it may a little bit impinge upon their sovereignty. The idea was, yes, Frontex may then with rapid intervention mechanism intervene, but such operation would still be subject to an operational plan, which has to be agreed upon also by the member state in question. Nonetheless, this goes quite far. What also I think is interesting is that we've seen, of course, in 2015 that problem where not only did Greece not implement the Schengen acquis up to standard, wasn't up to standards, but also we saw that other member states did not provide the necessary border guards to help Greece and did not provide enough technical equipment. And that is also an element that this proposal aims to remedy. But what is interesting then is that so far it was always possible for a member state to invoke an exception saying, hey, but we need these border guards or we need this equipment to discharge of our national tasks. So we have an emergency at home, we can't miss them right now. Now that exception is excluded in this proposal. And what I think is interesting is that there I see a problem with the idea that member states are ultimately responsible for their own internal security and that they are the ones to decide whether such an exceptional situation actually exists. That is no longer the case. So these are three elements that I think are quite revolutionary, but will they hold up in the Council? Just a quick timeline. So the Commission submitted this proposal on the 15th of December 2015, incredibly fast, really. The Council mandate for negotiations was concluded on the 6th of April. I mentioned the document there that's online. You can actually see all the amendments that the Council proposes. At the same time, the JHA Council of April 2016 already called for preparatory work to start. So in a way, already sort of taking a first step towards the establishment of this agency. The Economic and Social Committee adopted its opinion. There was no, and that's interesting, subsidiarity complaints from national parliaments. Although a lot of them did mention this, that there may be an issue with sovereignty. The Commission, the Libe Committee, I should say, adopted its report on the 30th of May 2016, and trialogue has actually, in fact, already started, and they hope for political agreement by July 2016. So that's incredibly fast. Now, let's have a look. What did the Council amend it? Quite a few things. I've just picked up on some things that I thought were interesting. It tries to define cross-border crime, sort of linking it more strictly to the element of external border control. It deleted the Coast Guard in the name, and I think that's related to that very sensitive element of search and rescue. In fact, search and rescue as a task for the agency was deleted. What you see now is a sort of more obscure formulation of it may involve Coast Guard functions. The request for migration management teams, these are these teams composed of national administrations and JHA agencies, so not only Frontex but also EASO and Europol. It was under the Commission proposal to be submitted to the Border Guard Agency. That is still the case, but now the Commission has been given a bigger role to establish the modalities. At least that's what the Council wants. Also interesting, it's no longer the Commission that takes the decision that there should be an intervention. It is the Council under the Council draft. And as we will see, very interesting, it's also the Parliament that agrees with that, so that should not be too much of a problem. And that is, of course, in view of the sensitive nature in terms of sovereignty. Then the obligation to contribute staff and equipment is mitigated in case of exceptional circumstances, but these exceptional circumstances are to be determined by the agency. For instance, on the basis of the conclusions of a vulnerability assessment. Participation on third country territory in joint operations will only be on voluntary basis. And then this is a very technical organizational thing. The introduction of a supervisory board has been deleted by the Council. Parliament. Parliament focuses a little bit more on the security dimension, because it's interesting that, as Richard said, the integrated border management has been defined for the first time in EU legislation, actually broadening the scope of Frontex also to measures within the area of free movement, so territorially, but also materially, also expanding it to cross-border crime, or at least making that very explicit. the European Parliament does want to have search and rescue in, and that's also, search and rescue is an old discussion. The whole discussion is, does the European Union have competence in this area? Why is that a discussion? There is a functioning framework for search and rescue under international law. We have the SAR and the SOLAS Convention, and member states do not want the European Union to get involved there. Now, I would agree with that, but I also disagree with the fact that there wouldn't be a competence for the European Union to endow the Frontex agency, at least with the power of organizing targeted search and rescue operations, because currently search and rescue is always taking place in the context of a border guard operation. So it it happens. You are there patrolling the high seas, you see that there is a search and rescue situation. At that point, the nature of the operation changes. But if you know that most of your border guard operations eventually end up in search and rescue operations, why not then be prepared for that, or even set out with that very purpose? The Parliament also strongly emphasizes that the vulnerability assessment mechanism needs to be complementary to the Schengen evaluation mechanism, and I would agree with that. I think that you need to be very careful that there's no duplication, although the Council and Frontex consistently stress that the nature of the two evaluations is different. The Schengen evaluation mechanism is a once in a 5-year checkup, whereas the vulnerability mechanism would be a rolling assessment. So also the Parliament wants the Council to take the decision, not the Commission. The Parliament reinforces the obligation to provide technical equipment, reinforces the obligation to inform Parliament, enhances at different points in the regulation the need for fundamental rights protection, although I would honestly say that that could be much better on some points, for instance, the provisions on data protection. Also deletes the supervisory board and wants not only the executive director to be appointed, but wants the deputy executive director to be appointed through the same procedure as the executive director and not by the management board. Good. Now, a bit on these migration management teams, these hotspots and the European Asylum Agency. These hotspots were initially, well, they were all of a sudden, they were there. They were mentioned for the first time in some technical study on Frontex, but really they were invented to enable the setting, the putting into place of the effectuation of this resettlement mechanism that never worked. The relocation, I should say, not resettlement, the relocation mechanism. Basically supporting Italy and Greece, making sure that other member states would take responsibility for the asylum claims of people present there. Now, that obviously was a disaster, and you see that those hotspots then changed function. They all of a sudden became the places, at least as far as Greece is concerned, to put into practice the EU-Turkey statement. So the place from where people would be then sent back to Turkey because their claims would be considered inadmissible because Turkey is a safe third country. The hotspots are not a place, it is said, they are a concept, and yet they're a concept that is that's never been defined really. In the amendments by the Council and the Parliament now, the hotspots are being defined as places where the member state authorities work together with the different union agencies. But I think what is interesting is that the first time that this is defined is in a regulation on a European border agency. It kind of shows the prominence of border control over other concerns, such as protection concerns. In the Commission proposal, the first request to send migration management teams to hotspots is to be put to the director of Frontex, who will then contact the other agencies. And that is interesting. In the Commission proposal, it is also the border guards that all of a sudden need to inform people that they think may have legitimate claims for international protection of their rights. That is not the task of a border agency. And also it's interesting then if you look at the EASO proposal, the proposal for European Asylum Agency, also that agency should be reinforced, should become more important. And it's interesting that there you see very much a parallel with Frontex. Also there's no decision-making powers for the agency. The agency does not deal with asylum claims, but it does get a very much enhanced role in providing operational and technical assistance. Even so, the resources and the funding made available for that agency are very limited compared to Frontex. Also, if you want to look at Frontex's role compared to that of the European Asylum Agency in these migration management teams and in the hotspot approach, you just have to compare Article 21 and Article 17 of the different proposals. And you see that Frontex has a much more prominent role, already so in practice, in coordinating the work at the hotspots. Just like the Frontex proposal foresees in Frontex or the border agency's action at times of a disproportionate pressure, the same is there for the European Asylum Agency. There is the possibility of sending sort of emergency teams to countries that are facing disproportionate pressure, but the consequences are much less far-reaching than in the case of Frontex. There's no such right to intervene or something in the case of asylum. Then fundamental rights concerns with the Commission proposal. I will not say much about return because we have here the Fundamental Rights Officer of Frontex who will go into that tomorrow, I think, and there's a special session this afternoon on return. Suffice to say that there are some concerns when it comes to return, I think. Data protection, the European Data Protection Supervisor came out with a scathing report, I think, and I must say that when you look at the amendments of the Parliament and the Council, some of them have been taken into account, but only to a very limited extent, and the EDPS was very critical, rightly so, I think, of questions of purpose limitation. What you see in the proposal is the agency gets broad powers to simply process personal data, not just on what it can do now, people that are smuggling, but also on any irregular migrant. And it doesn't really say which data. What is normal is you would say you can take A, photograph, B, fingerprints. No, it just says you can take personal data on an irregular migrant. And that's, in terms of purpose limitation, it's very badly drafted, I think. Also, because the agency has these powers when it comes to irregular migration, but also as regards internal security, those are two different data protection frameworks. Finally, the cooperation with third countries. You need to be very careful who you cooperate with, as the cooperation with Turkey shows, but also think about Libya. So there could be something that could be much better formulated with much more safeguards in place. There are some improvements there in the European Parliament draft, I must say. Then the fundamental rights accountability. This has been an issue for a long time. The idea is very often that, well, it's very often presented by the agency saying, we don't have executive powers, hence any responsibility lies with the member states. Various legal scholars challenge that on the basis of positive obligations. Yes, main responsibility may be with the member states, but you could also be responsible, Frontex, because you are there, you see this happening, you may have some degree of control over what is happening. But Frontex has made huge steps, especially as after the introduction of the 2011 regulation, in which there were a lot of extra safeguards introduced, including where the fundamental rights officer was put into, the position was created, there was a consultative forum introduced. The proposal has some good new elements, such as the individual complaints mechanism, for which the European Ombudsman had already been making recommendations. On the other hand, and this may just be the result of badly drafting, there's also some elements that seem to weaken the position of the fundamental rights officer. The obligation to report to the consultative forum, the monitoring that was made compulsory in the 2011 regulation, that all of a sudden seems to be gone. And also the individual complaints mechanism itself, it's fraught with very unclear legal language, a lack of deadlines, a lack of formal requirements. So it can only be hoped that the final text will either give the agency the power to set up, to basically take an implementing decision on how to shape this individual complaints mechanism, or will itself give clear obligations on the member states how to respond and how to work with the agency. So, some final remarks. Most important thing I think to take home is no transfer of executive power to the European Border and Coast Guard Agency, which I saw actually in the latest council draft will still be called Frontex, which seems very smart to me. You don't have to change all the name tags and the logo. A lot of the innovative elements have been watered down by the co-legislator. I do think that the proposal still is exemplary of the undue focus on borders in this whole crisis. I do think there's a need for a legal basis for the hotspot approach, and that should not be then in the Frontex regulation. What is interesting is that the Parliament does enter a provision, does propose a provision where it clearly says, since the hotspot approach has not been defined, everyone should work within the limits of their own competence, all agencies, both national and European. I do think it's problematic that this current unclear division of responsibility remains, even though there may not be another possibility within the current constitutional setup of the European Union, where you have the ultimate responsibility for internal security with the member states. But that becomes increasingly problematic as you reinforce that agency. There may be more and more positive obligations on the agency. I think the proposal leaves specific fundamental rights concerns unaddressed, and I think that the individual complaints mechanism, as I said, is to be applauded, but requires to be elaborated. And with that, I conclude. Thank you very much.
To complement the overview that it was provided with some other legal safeguards around return from yesterday, I speak on my behalf and complementing a little bit what was said about my role. I actually have two main tasks. I advise Frontex on fundamental rights issues on a daily basis. It's mainly focused on operational issues, and I also monitor on the ground. So that means I go to all these operations regularly, including return operations, which is going to be the focus of my presentation. But of course, feel free to ask anything later during the turn of questions. I wanted to focus on returns first because, of course, there was a lot of prior speakers mentioning it, but also because I actually believe that they are the most sensitive operations that Frontex is coordinating. And in my experience, which doesn't mean that I have seen this happening, but it could theoretically be the case, anything can go wrong in really a split of a second. This is the sad truth of the operations. It's highly sensitive environment and in a closed doors, and it's not very easy to manage. Frontex coordinates joint return operations for already 6 years, I believe. And the latest trend has been to start coordinating also readmissions to Turkey, as you probably have heard. I will speak everything I do on my own behalf. I am independent in my functions within Frontex, and therefore I have actually all these views are my own. Doesn't mean that they are attributable to the agency. I will do 3 things. It works. Explain very briefly. I want to restrict my presentation to 10-15 minutes so that you have time for questions. To fundamental rights and Frontex activities, the specifics of joint return operations in the Code of Conduct and Guide on Joint Return Operations that we have just published, and a little bit of an overview on monitoring of return operations, which to me is extremely important matter. What, as Lenneke put it, it was quite critical in the press and in the public sphere about the fundamental rights adherence or not of Frontex deployed officers. Therefore, the regulation establishing Frontex was amended in 2011 to introduce the following statement, which actually is quite condensed in terms of fundamental rights. It says, Frontex shall fulfill its tasks, which are to coordinate operations in support of member states' border management activities, in full compliance with Union law, including the Charter of Fundamental Rights, the relevant international law, including the 1951 Convention, obligations related to access to international protection, in particular the principle of non-refoulement, and fundamental rights, which means in my practical daily life, I have resources in the UN, the Council of Europe, and the EU legislation to make a point and defend fundamental rights arguments within the activities. Furthermore, in Article 26, it was amended, including a new paragraph stating that Frontex shall put in place an effective mechanism to monitor the respect of fundamental rights in all the activities. And this is where I come into the picture, I am a tool within that monitoring system with monitoring powers myself. So I'm not the monitoring system in itself, but I'm part of it. Of course, this includes all the activities of Frontex, therefore cooperation, return cooperation is included, and also cooperation with third countries. The fundamental rights obligation in a joint return operation have been discussed extensively with member states and within Frontex and with other EU bodies, and it implies three levels of EU, so three levels of the legislation. First, of course, the escorts participate in the joint return operations are national escorts, therefore they are obliged by the national law. Then there is the EU law, the Charter of Fundamental Rights for my concern, and then international law and the Return Directive, of course, and international law, the European Convention or the UN treaties. I will try to reduce. What are the main fundamental rights at stake during a return operation? Human dignity, basic needs, of course. Freedom from torture and inhuman or degrading treatment. This is normally the most, one of the most endangered ones. Non-discrimination, right to life, right to an effective remedy, and protection of vulnerable persons. The right to effective remedy was very extensively explained yesterday, so I will not stay on that one. I will just focus on what the Code of Conduct and the guide say about some specifics. The Code of Conduct describes common procedures for joint return operations coordinated by Frontex and tries to include as much as possible procedures to ensure return in a humane manner and with full respect on fundamental rights. For instance, Article 4 of this code states that the return operation can be interrupted or terminated in case of unsafety or serious violations of fundamental rights. This has not been the case yet, but at least that since my start in Frontex 3.5 years ago. But I mean, it's not, of course, it has to be contemplated as a possibility that there is such a massive situation that the operation needs to be actually aborted. One of the most sensitive points, of course, during these operations are the use of coercive measures and to what extent and when and what type of coercive measures. The Code of Conduct says that the use is only when strictly necessary. It actually invites for an individual risk assessment of the need of coercive measures. Its use has to be proportional and with reasonable force, and they are forbidden to use measures that can provoke asphyxia or the use of sedatives during return operations. The code also obliges to report all violations of the code, including any issue related to fundamental rights by the persons participating on it. And for this purpose, okay, we developed further, there was a guide on joint return operations. I think it was drafted in 2008, and of course with all the evolution on case law and all the return directive and everything, we thought it was time to revise it. We have been on this exercise for quite a while, and we just published it. I don't have copies. I have copies of the Code of Conduct. I left them outside. The guide is available in the webpage of Frontex. It was actually published on the webpage only last week, and we hope to be able to distribute hard copies soon. The purpose of the guide is to provide more operational guidance, not so much behavioral ones, but operational, how to organize joint return operations by air, coordinated by Frontex. And there's we did quite an extensive consultation during this process with member states, with the Consultative Forum on Fundamental Rights, which is the advisory body on Frontex on fundamental rights, composed of 15 members, and the Committee of the Prevention of Torture of the Council of Europe. For instance, in this guide, we have a specific aspects related to embarkation and the treatment of minors during flights. This means families, not unaccompanied minors. This is one of the bans that the operational plans of joint operations imposes. There are no unaccompanied minors in Frontex flights, to my knowledge, that I have, and is forbidden. And we have tried to enhance a lot the presence and the work of medical doctors during these operations, of course, in view of ensuring the right to health of everybody on board. The content is a little bit explained there. One matter that I have worked a lot these last weeks is actually the fact that I firmly believe that operationally and from a fundamental rights perspective, there is absolutely no difference between among the fundamental rights safeguards that a joint operation, joint return operation by plane normally, prototypically will imply, and a readmission operation that is now undertaken with Turkey. They are the same type of operation when it comes to looking into what safeguards you need to have there. Of course, legally they are very different, but from a fundamental rights perspective and the needs of the people inside, I don't see any. So I'm trying to work towards the direction of using the guide and using the code of conduct in these operations. And I go with the last point on monitoring. You probably all know that the return directive established the need for member states to provide for an effective monitoring system of return operations. This is likely to be one of the most debated aspects of the return directive in its history, and there are very good reasons for it. What is effective? Is it independent? You know, there has been a lot of evolution in this front, and I have followed it with great interest, because in some, the importance of monitoring system is not only for the returnees, it's also for everybody on board. Of course, it actually aims to ensure that people are returned in a humane manner and with full respect of fundamental rights, observing the standards that have been set up by the EU Return Directive itself, all the case law, and the Committee for the Prevention of Torture. It adds transparency and accountability to the operations, but it also ensures the safety and the protection not only of the returnees, but also of the escorts, because there have been incidents where escorts were actually injured in practice. The new regulation that was discussed yesterday includes a specific system of complaints, individual complaints. It was briefly mentioned yesterday, and of course the return operations are going to be part of that complaint mechanism. It also includes the establishment of a pool of monitors by Frontex, which I'm not entirely sure what is the latest development in this, but in the version of the Commission it was members of the national monitoring mechanisms that were going to be kind of seconded to the Frontex pool in order to be able to ensure presence of a monitor in all the Frontex flights. There is a basic standard and rights of monitors during this flight. Monitors access to information prior to the flight, during the pre-embarkation meeting. They participate in the briefings, the possibility, there was foreseen in the Code of Conduct, the possibility for a member state to monitor on behalf of another member state. This actually was put in the theory, but it was never implemented. And now with this pool, that is going to actually have to happen, because that's exactly the point of a pool. There will be one monitor and not one per country. There is also the possibility for observers to be on board. This has been 3 times already the case of the Committee of the Prevention of Torture. They have monitored 3 member states organizing flights, but it was Frontex coordinated. And there was also foreseen in the Code of Conduct the reporting and sanction mechanism, but now with the complaints it will be effectively put out in the public. I have tried to actually do something else during my time in Frontex, which is to include in this equation of monitoring the monitoring upon arrival. This has been not not systematically done, only for certain countries where the national preventive mechanism of torture was especially active, for instance, in the area of the Western Balkans. And what we try to do is notify the ombudsman that the flight is coming so that they can actually receive the people and have an initial interview assessing vulnerabilities already before people are taken to wherever it is that they are returning to, normally their homes. And well, in a nutshell, a monitoring system in Frontex is, I always draw it as a graphic in a circle that illustrates what could happen in case of an incident. There is, of course, information, verification of the information. This is always done by the member state involved. Frontex doesn't have investigative powers. Then what I perform is the analysis of the information and the impact on fundamental rights, and then we do a final report where I try to, of course, to put forward some measures for follow-up in order to prevent similar incidents in the future, and then we go again to the beginning of the prevention. And for instance, one of the things we have done is when I have observed certain procedural aspects of I will give you a very concrete example. Embarkation of children and families in different member states was done in different ways. And of course, from a fundamental rights perspective, there was one preferred to the other. And I put it forward in a discussion with member states, and everybody agreed that it was very easy to be implemented in practice. That, for instance, when you have families, you don't put them in the same bus as you have detainees that are actually handcuffed. And they were separated embarkation in different seats in different places, areas of the plane, and then children do not need to actually be exposed to possible episodes of violence when there are other types of profiles in the same flight, for instance. And this was quite easily undertaken by all the people involved. So I will leave it here, and I'm more than ready to get your questions. Thank you very much.